What's up, everybody? Welcome back into another episode of The Lawyer You Know. I was planning on doing a reaction to Lori Vallow's opening statement of trial number 2 in Arizona, where she is representing herself. She tried to delay because she's sick, does not want to be there, has been butting heads with the judge already throughout jury selection. He ordered her to show up. They picked the jury, and now she's giving her opening statement. But with the first witness on the stand, Brandon Boudreaux, who is the victim and the main witness in this case, we already have fireworks. So many people sending me clips of Lori Vallow getting thrown out of the courtroom. We will react to that and some other things the judge has already had to do in this trial that I don't think we saw very much of, if any, from the last trial. So make sure you guys hit the like button. Let me know in the comments if you're watching this trial for Lori Vallow. If you're not and you don't care about it and you don't want any content on this, just let me know. But I've gotten a lot of questions on it and a lot of people sending these clips. So that's why we're here, breaking it down. Make sure you guys hit the like button. Let's get to it. So the first thing we are going to react to is Lori's opening statement to give us an idea of how she's going to handle this case. We remember from the last trial, her opening statement was what it was, but at least she was trying to kind of give us a roadmap of where she's going to go. Does she take the same strategy in this case, or does she change, and why? Let's take a listen together.
Ladies and gentlemen of the jury, here we are at trial. And the judicial system can be difficult to understand at times. There are laws and rules and statutes that govern how things will proceed in this trial. You yesterday got to hear the preliminary jury instruction, so you kind of got an order of how things are going to go. In order for someone to be charged with a crime, as I have been—
Your Honor, I'm going to object to argument versus an opening statement.
I'll remind the defendant an opening statement should be a preview of what is to be expected at trial. So go ahead.
that law enforcement presents evidence that they gather, and the state prosecutors are going to present that to you. Sometimes the state charges a defendant with a crime. They have charged me with a crime, a very serious crime. Sometimes they take the allegations to a grand jury to decide if the defendant
I'm going
should
to
be
object
charged.
again, Your Honor. Improper
That's,
argument. Asked to strike.
Hold on. The jury should.
He's like, settle down, settle down. He agrees with her, with the prosecutor, but this sounds a little bit more like Lori Vallow's closing from last trial than her opening, and she's trying to explain how the criminal justice system is unfair, especially unfair to her. It's like the 1.25 felt a little fast. Normal feels a little slow. Let's go to like 1.15. Let's try that.
Disregard that last comment. How the charges arrived here are not for the jury's consideration. The prior proceedings are not for the jury's consideration. Please proceed.
The state or the prosecution will then take the information gathered, the evidence from law enforcement, and present to you a story, a theory, their hypothesis of what happened. In this case, the prosecutor was not present during this alleged crime. The Gilbert Police Department was not present during this alleged crime. So it is their job to fill in the gaps, make up a theory, and present it to you, the jury, at trial. This is their job.
Definitely argument and saying make up a theory and try to prove it.
They are not witness to the actual events because they weren't there that day with Brandon at the house when this alleged shooting occurred. This case is about a conspiracy. And a conspiracy is when two or more people make an agreement to commit a crime. They have to willingly and knowingly participate. Conspiracy is an ancient word that appears in the Bible on many occasions. Judas conspired against Jesus with the chief priests for
I'm going to
30 pieces of silver.
object to, unless this is being presented at trial, I'm not sure that this is appropriate opening.
You can give analogies to talk about what the crime is and give examples. Maybe it's borderline argument, but I mean, she's going to object to it. We've already seen that the judge made comments that I think he kind of said he shouldn't have made, and he kind of agreed. And I agree with that on the first trial, talking about how she's comparing herself to religious figures and things like that. And she tried to say that was some kind of religious discrimination, which it's very clearly not. But now here she is using more biblical analogies, which should be expected from Lori Vallow. Not sure you'd want to compare yourself with Judas for all those not familiar with the Bible. You don't usually want to compare yourself and analogize yourself with Judas.
What is the legal objection?
Well, you're arguing. The opening statement is not argument. I'm going to allow it briefly, but I may cut you off depending on where you're going with that.
Cain conspired against Abel, his brother. This case is a case of conspiracy. The charge against me is that I conspired with my brother, Alex Cox, to murder my niece's husband, Brandon Boudreaux. But you will find, as you begin to see the evidence put forth in this case, that there was not any animosity between Brandon and myself. I personally did not have any motivation to have harm come to Brandon. In fact, Brandon and I had a very friendly relationship all of the time that I have known him. I first met Brandon when he was marrying my niece, Melanie.
Your Honor, I'm going to object to, unless the defendant's
Hold on.
testifying.
Can I have the parties approach briefly? Can I have you approach?
So it sounded to me, I'll just say, now maybe she's wrong, and criminal defense attorneys have been wrong about what's going to come out in evidence, but Brandon Boudreaux is going to testify. And so this could be what she expects Brandon Boudreaux to testify to, which is an appropriate part of the information she can add into her opening statement. They approach, and this is going to be interesting when we talk a little bit later about what's happening in this trial.
Approach briefly.
We're going to skip this.
I first met Brandon when he was marrying my niece, Melanie. Melanie and I are very close because my sister, her mother, passed away when she was just 9 years old. So Melanie and I think of each other and love each other like a mother and daughter, even though we are aunt and niece. So our families remained close, Melanie and Brandon's family and my family. And in each other's lives, like everyday lives. We spent holidays together and shared in everyday life. I was there for Melanie and Brandon's wedding and for the birth of all 4 of their children. I was also very close to all 4 of their children. In this case, you will hear Brandon himself tell you that someone shot a gun at his car. You will learn in this testimony that Brandon was not hurt. You will learn that he wasn't even sure what had happened. But you will hear that Brandon immediately
Just because he wasn't hurt, obviously not an element to the crime they're trying to choose here, was his attempt.
blamed me. Which begs the question, was I an enemy to Brandon? That is news to me, and hopefully by the end of this trial, we will all have some answers to that question. In this case, you will learn that Brandon had called 911 and Gilbert Police did respond. You will learn that Brandon speaks of a puke green Jeep, and then he offers the officers a camo green color that he's speaking of on his phone. He says a green Jeep. Then you will hear the neighbor who says that it was a dark blue Jeep that was parked in front of the neighbor's house. You will learn that Brandon very quickly hired a private investigator to find out where I was living out of the state of Arizona so he could inform the police. You will see Brandon exchange email information with Detective Pillar, the case agent in this case, about my whereabouts and about the financial dealings of my niece, Melanie Boudreaux.
And it's funny that she brings that up in opening, because that's the portion of testimony that has some interesting things about what the judge has to do with Lori Vallow during the trial.
You will learn that Brandon was not particularly satisfied with the investigation that Gilbert Police was conducting, so he did his own investigation, hiring his own private investigator to follow his wife, Melanie Boudreaux. You will find out that Brandon had access to the VIN number of a Jeep and gave it to the police. You will find out that after that event, he quickly changed his story from a camo green Jeep to a gray Jeep. You will then learn that Brandon continued to provide information he was personally finding out to Detective Pillar, the case agent in this case. You will learn that Detective Pillar and Brandon discussed through email how they can demonstrate Melanie's financial gain if Brandon were to have died around October 2nd, 2019. This is what a conspiracy looks like. 2 people trying to set up another person for a crime. My niece, Melanie Boudreaux, is named.
So she's saying they're conspiring against her, Lori Vallow, to set up a crime against her. Sound familiar? I wonder if she's watching things happening around the country. The police and the alleged victims or people around that were there at the time the crime was committed, trying to conspire and pin it on the girl, maybe. It sounds like that's kind of the theme she's trying to go with here. Also, you can see this in some of her questioning, her trying to point out the inconsistencies. What color was the Jeep? Where was the Jeep? Who was it? And if Alex Cox was doing something, maybe Lori Vallow didn't know his every move. She didn't know every single thing he was doing. Is she going to point the finger at Alex Cox to try and clear her name?
Named by the state as a co-conspirator. However, she has not been charged with the
I'm
crime.
going to object
But
and
I
have that
have.
struck as well, Your Honor.
Jury should disregard that statement. You're going to receive an instruction later that all persons that may be involved would not necessarily be charged or called as witnesses, and you'll follow those instructions later. Go ahead.
I was not living in Arizona at the time this alleged incident happened on October 2nd, 2019. I was not even aware such an event had taken place. I did have a close relationship with my brother Alex, but I was not aware of his every move. Melanie also had a close relationship with Alex, but also was not aware of his location at all times. Brandon and Alex also had a good relationship until this accusation. They saw each other frequently at all of our family parties and get-togethers and would often be seen laughing and talking. Alex was a comedian who kept our family laughing. Alex passed away in December 2019 of natural causes, so he is not here to defend himself.
And I'm going to object again to that as well, since he's not party to this. He's
All
not
right,
here.
I'll just remind the jury that what is said in opening statements is not evidence. It's not sworn testimony. Please proceed.
Although the state has alleged that there are several co-conspirators in this case, I am the only one being charged with a crime. So you will be the judge. You will hear and see evidence presented by the state. The state has, according to the law, 100% burden to prove to you
I'm going
that
to
a
object to the statement
crime-
of the law in terms of 100%.
All right, again, this is
They have 100% of the burden, but beyond a reasonable doubt is not 100%.
a little bit bordering on argument, but the jury will receive the instructions on what is and what is not proof beyond a reasonable doubt.
the state has the burden to prove that a crime has been committed here and that I committed that crime. That is the way the law is written. I do not have to show any evidence or put up a defense. I do not have to testify. That is the law. The prosecutors from the state have to prove to you that I conspired, meaning made an agreement with my brother to murder Brandon. So you will decide. Right now, according to the law, I am innocent. I remain innocent until the state of Arizona and its prosecutors show you enough evidence to convince you that I had anything to do with this alleged crime. And I want you to look carefully and determine if this event was a crime at all. Did a shooting actually occur? Only Brandon claims that it did. Only Brandon names me.
So she's going to try to poke holes in Brandon's testimony because he's the only one that says there was. He was, in fact, the victim. So he's probably the only one that actually can say there is, unless somebody's going to admit to it. But this is just, we're kind of getting her theory of defense.
Me and Alex. You will learn that Brandon himself did own a gun. You will learn that Brandon knew how to shoot his gun. You will learn that Brandon and Melanie were going through a divorce. And you will learn that even though Brandon is the one who actually filed for a divorce, he was blaming me for his divorce. You will learn that
That's her hitting bias, credibility issues potentially with Brandon, who is the state's most important witness.
information that the Gilbert Police Department and Detective Pillar, the case agent on this case, learned about me and my brother Alex was from Brandon Boudreaux. You will learn that Brandon and Detective Pillar communicated frequently and were on a first name basis. I want you to look closely at the motivation of Brandon and the Gilbert Police Department because I'm the only one charged with the crime. And I need you to decipher what really happened here because I'm the only one who's being asked to pay a consequence for this
And
crime.
again, Your Honor, I'm going to ask to object and strike that. There's
Sustained, the jury in their instructions received an instruction that said the jury is not to consider a penalty. That will be in the final instructions area as well. The jury's job is to determine whether or not the state has proved the case beyond a reasonable doubt or the charge beyond a reasonable doubt. Go ahead, proceed.
You will hear many references during this trial about the state versus Lori Daybell. Well, who is the state? The state are the prosecutors.
I object to argument and relevance.
Sustain.
And you, the jury, are brought in to stand between the state and me.
And I'm going to object again to improper statement of the law, argument and relevance.
Sustain.
She's trying to make some of these arguments we've seen other lawyers make. She's just doing it wrong. They have 100% of the burden. The jury is the place where it's an even playing field. She started out the presumption of innocence, but she's twisting it in a way that's just not a correct statement of the law, which she's not a lawyer. So what can we really expect from her? But she continues to try to do this on her own, and she continues to struggle in this exact way.
You are here to say if a crime has even been committed at all. You are here to say if I committed this very crime and if the state proved this to you beyond a reasonable doubt. If at the end of this trial you have reasonable doubt, then I remain innocent. If the state does not prove to you that I, 1, committed a crime, and 2, committed this crime, then I remain innocent. In this case, you will hear a lot of speculation. The definition of speculation is an idea or guess about something that is not known. During this trial, the state will try to
She's arguing for sure, but Karina Kay is prosecutor is kind of picking and choosing what she's going to object to and whatnot, because you don't want to object 100 times, but she's just objecting to the very large mistakes Lori's making, not these, and the completely inadmissible, inappropriate things that Lori is saying. She's objecting to those.
convince you that I committed this crime by using speculation, innuendo, and insinuation. And the state is hoping that this will be enough. In this trial, you will in fact witness a power struggle between the state and the defendant.
Your Honor,
For
I'm
what
gonna
a fact
object to
really
argument.
is.
Sustain.
Because they want to convince you, the jury, that a fact is speculation, that a fact is innuendo, that a fact is insinuation, that they knew what I was thinking, what I was feeling, what I was planning, when they don't know at all. You, the jury, have all the power to decide what the facts are and what they're not. Not the state, not the judge, not law enforcement, you. So I implore you to listen carefully and decide for yourselves if the state's theory really makes logical sense. What motivation did I have? What malice have I ever shown to anyone? What benefit would I gain? I am a person who loves all people and has no malice towards anyone, not even the prosecutors who wrongfully try to convict me.
Your Honor, I'm going to object again to relevance and to argument.
Sustain.
It's definitely argument. It's definitely not coming in a trial. I don't think anybody's going to testify to that.
I am all about spreading love and will continue to do so even after this trial is complete, no matter the result. Thank you.
All right. So now we're going to take a look at a couple clips you guys have sent me. I watched one of these. I didn't watch the other. So we're going to just be live reacting here. And I'll give you some context around this one because I did see this. The other one, I don't know if it's a repeat of this or what, but we'll take a look at it as well just to make sure we're not missing anything. And then I'll give you some interesting things that have been happening throughout the testimony. I've only caught some of it, right? Some parts of it here and there and some recaps of it from Nate Eaton. But I did want to play this because it's a really interesting legal thing happening here.
That sidebar again discussed similar issues of if the defendant brings in evidence or testimony that she was a good person and no ill intent and those sorts of things, and specific acts of
He's looking for character evidence is what he's saying. Like if she's trying to bring in good character evidence, then they're going to be able to dig into that. It's not the same as saying no malice or no intent or no motive.
of her being a good person, it could open the door to other things that she may not want the door open to.
We all know what that is.
The state, the defendant, and advisory counsel were at the bench when we had that short 1 minute sidebar, but I don't know if anyone wants to supplement the record on that. Ms. Kay?
Just, Your Honor, that again, the state did raise any issue of character evidence under 404A and 405, that if the defendant opens the door and tries to advise that she is a good person, a peaceful person, a kind person, a loving person, any of those other types of things that we believe that would allow us under 405 to then bring in specific acts such as the murder of her children, her husband, and her current husband's wife.
All right.
Which would also be 404B that they withdrew.
No, it'd be
Yeah,
405.
they withdrew it, but if you bring up 404 that you.
Then all 404B is in, or do we get a hearing on what 404B can come in? If I open the door, do I get a hearing? We stop trial and I get a hearing
Have a
on,
very- Stop. We'll have a very short hearing, okay? If you're going to introduce how you have great character and good character, we're going to have a short hearing on what evidence that they can bring in to rebut that character, which could
Okay.
include being convicted of 4 murders.
and
So
would you
talk
like,
to your advisory council.
The judge is like, yeah, sure, we'll have a hearing. We'll have a hearing because Lori Vallow is pushing for her rights. The problem is she's pushing these buttons I don't think she's going to like the result of. And she's pushing and she's basically calling the judge. She's trying to make him seem biased, trying to make him seem like he's against her. That's been kind of her theme throughout this process ever since she tried to get him recused. To me, she has been way more combative this trial. And he has had to be way more restrictive this trial. I feel like he wasn't that restrictive last trial. And he is very annoyed with her. And he's like, you're sitting there acting like you're this great person, spreading the love, never done anything wrong. When you're the reason so many people in your family and in the families around you are no longer with us. So you want your hearing, you have your hearing. We'll have how much of that information is going to come in. It's all bad. It's just how much is going to come in if you really want to open this door. Don't threaten me with a good time, right? She's acting like she's threatening him, like she has some kind of leverage. And he's like, you don't have the cards you think you have, Ms. Vallow Daybell.
Your counsel during the break. And
you don't need to yell at me either.
Yelling at you, okay?
Yeah, you are. And
He's being stern. I don't think he's yelling, but he's being stern. I'll back it up so you guys can be the judge.
Which could
Okay.
include being convicted of 4 murders.
and
So
would you
talk
like,
to your advisory counsel during the break. And
you don't need to yell at me either.
yelling at you, okay?
He's definitely not yelling, but that is a nice gaslighting moment for Lori Vallow.
Yeah, you are. And you do not need to talk
Okay.
to me that way. I'm
Take her
very
out. Take
courteous.
her out.
I'm very courteous to
Take
you.
her out.
Take her out. He's kicking her out. He's like, you know what? Take her out. I'm done with her. I don't want to say something I regret. That's what I think he's doing at this point. He's like, I'm not yelling at you, but the way you're talking to me, I'd like for you to step out and talk to your advisory council. I'm done talking to you. Don't yell at me. Just calm down. That's what she's doing as she is intentionally frustrating him. And he's like, take her out. Take her out. I've had enough.
You are. And you do not need to talk
Okay.
to me that way. I'm
Take her
very
out.
Don't
courteous.
talk to me that way as if, show her some respect, Judge. Show her some respect.
At me either.
Yelling at you, okay?
Yeah, you are. And you do not need to talk
Okay.
to me that way. I'm
Take her
very
out. Take
courteous.
her out.
I'm very courteous to
Take
you.
her out. No, you have been nothing near courteous to me during the course of these proceedings. Talk with your advisory council about the rest of your cross. We're going to resume in 15 minutes.
All right.
So he literally kicks her out of the courtroom to talk to her advisory council. I don't blame him. He's frustrated. Is he being overly kind and handling her with kid gloves? No. Does he have to? No. He's being respectful enough. He's trying to lay down the rules, right? Because that's important. That's his job, to lay the ground rules, make sure she sticks to them, make sure this is a fair trial, make sure it's not a mockery of our judicial system, make sure it's fair to the state, to the victims, to the witnesses, to everybody involved. And he's like, get out of here and go talk to your advisory council. We're going to play this clip, and then we'll talk about a little bit of the stuff that's happened during the trial.
Yesterday, Mr. Abernathy, one of the advisory council, said he would be late today because he had a childcare issue, but that Ms. Hicks, the other advisory council, would be here and ready to start at 9:30. What time did that email come in?
Just the email came in at 9:20, but she was printing off pictures.
All right, so we got an email at 9:20 saying she's still at her office printing off pictures, which is wholly unacceptable. Ms. Daybell, you represent yourself. You do not need your advisory council here.
So that is one of the interesting things. I've never seen it done like this, but she no longer has a right to counsel sitting there next to her. She has waived that right and is representing herself. They can watch the live stream and give her advice if she needs it and answer her questions if she needs it. I've never seen it be held. Now, obviously, if it's a criminal defense attorney representing a defendant, you sit there and it may be annoying, but that's a constitutionally protected person that must be there before this trial starts. But Lori Vallow Daybell has waived that right and taken on that role herself So the fact that these lawyers are late and even later than they said they were going to be, and the one that was not going to be, she definitely doesn't have a right for both of her advisory counsels to be sitting there during her trial when she has decided to represent herself, which is just another example of the judge not being overly harsh. The fact that he even let her wait until 9:30 till her advisory counsel was going to be there is more than he had to do, in my opinion. So this happened before he threw her out, before that whole exchange earlier.
But I'm going to split the difference. She's being sent an email that says if she's not here at 9:50, we're going to start.
That is more of a grace period than they deserve at this point. Now, if it's a criminal defense attorney, he can say all he wants to about them starting without him. He's not going to start without them because of the constitutional rights and protections that criminal defendants have. He may reprimand them and ream them and yell at them for being late. He could even sanction them potentially for being late if they violate a court order and he orders them to be there at 9:30. You don't want to be late, but all of this is very different when somebody chooses to represent themselves.
If there's pictures that need to be printed off, staff can do that. Staff can bring it over later, but should have been here at 9:30. If this were,
And I don't know the rules of Arizona. If they say you waive your right to counsel, but you still have a right to advisory counsel sitting next to you, that would be very unusual to me.
federal court, she'd probably be going into custody. I mean, this is ridiculous.
He is right. Federal court is, we call it big boy court, and they don't take this type of stuff lightly. I don't know that she'd necessarily be going to jail, but the judge would have her there in order to show cause and have her explain herself and why it's necessary that she's this late, because she absolutely should not have been this late, especially knowing the judge said, don't.
All right, I'm just letting everyone know what the holdup is. We're going to start at 9:50.
Judge, at 9:50, I do need to make a record regarding character evidence and the defendant opening the door before she questions some witnesses.
Okay,
Just want to make sure that that's out there so she's aware of that.
we'll do that at 9:50.
So I think Lori Vallow is pushing the boundaries way more in this trial. And the testimony is still going on when I'm recording this. So as this trial goes, I think she is going to open the door. I think the judge is going to allow some character evidence in. And if I was Trina K at this point and she's going to do it and she's been advised of it a million times, I'm going to run through it as much as the judge wants me to. Usually prosecutors are worrying about appellate issues. Trina K seemed to be worried about appellate issues. But at this point, you've got the first conviction with Charles Vallow. You've got the 3 convictions in Idaho, multiple life sentences. Go ahead. If she really wants to open the door, let her open the door, bring it in and see if some appellate court really is going to overturn this verdict after Lori Vallow has been warned over and over and over and over and over again. It seems like with one of the witnesses, the judge is going to let them talk about some of his discussions that may cross over, some of Brandon Boudreaux's discussions that may cross over with some of the other cases, and definitely with Melanie, her niece. And what was also interesting, and that hasn't happened, I don't remember it happening in the first trial of Lori Vallow, which I watched the entirety of. This one I haven't been able to because of other things going on, and obviously the Karen Reed trial happening at the same time. But the judge has given her, write this down, Lori. These are the specific questions you can ask on cross of Brandon Boudreaux. Trina K, prosecutor, write this down. These are the specific questions you can get to. And when a judge starts doing things like that, it means everybody needs to be very, very careful about what questions they're going to ask, what doors they're going to open, because I'm going to allow it as the judge. If you really want to go too far and you want to push these boundaries, I'll let you, and it's your funeral if you really want to do that, because we know as soon as the jury hears about other convictions, if they don't know about it already, it's over for Lori Vallow. I already think she has a very, very slim to none chance of winning this, but even less if any of that comes in. Any of the other bad acts evidence comes in, she's toast if she's not toast already. And most criminal defendants know that. Criminal defense attorneys absolutely know that, which is why they want to do everything they can to not allow that stuff to come in. Lori Vallow needs to be very, very careful about what she brings in if she wants any chance to win at this trial. She's got some inconsistencies. She's got not a lot of, eyewitness testimony against her. She's got potentially that Brandon Boudreaux was not happy about the investigation. So she has a potentially not perfect investigation by law enforcement to try and work with as best as she can. I don't think she's got a great chance, but it's better than what she has if she allows all the other bad acts to come in by saying what a great person she is and how she has no malice, never done anything wrong, is a generally nice person who loves people and has never done anything to conspire or hurt anybody in her life. It's not going to work out well if she opens that door. But let me know what other questions you guys have. Send me the clips if you guys have some wow moments in this trial. I don't think this is the last time there are going to be fireworks in Lori Vallow Daybell's potentially last criminal trial in the long list of criminal actions that she has done And as far as this one goes, allegedly done, as she is still presumed innocent with Brandon Boudreaux as the victim. We'll see how long that lasts. So it's all I got. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.